Chibayole.
Daily list for admission, item 1.
Yes.
Lordship, I have received affidavit from the state respondent last week, Lordship, and this is a simple matter, and it may be disposed of in the admission stage, Lordship. So it may be kindly taken up tomorrow or the after tomorrow, Lordship.
This is your the plaint did the written because you didn't file your written statement.
Lordship, yes, it was
Rejected.
yeah, it was not. This is challenging the ex parte judgment, Lordship. I was
Against that, you have come under a civil revision.
Civil revision, Lordship, yes. This is a 2012 matters.
2000?
2012, Lordship.
Yes. Miss Mary, you are appearing.
Yes,
Sorry.
my lord.
Sorry, huh?
Yes, my lord. I am appearing for the sole respondent.
And is this revision petition maintainable? Is there any alternative remedy?
Yes, my lord. I have submitted that in my additional
What
affidavit.
under which provision?
CPC.
Which provision?
Order.
Order
11.
9.
Order. Yes, my lord.
You don't know today. Why? You have not prepared the draft.
I have, my lord.
Where is your brief today?
My lord.
Ma'am, where is your brief today? Why are you borrowing a copy from the other side? Is this the manner you appear before a constitutional court?
No,
This
my
is the first item. You have filed the objection.
Yes,
You
my
do
lord.
not know under what provision you have objected the maintainability of the revision petition. You do not have a copy of the objection. You don't have a file.
Lordship, I apologize for that.
No, please do not do this. I don't appreciate such kind of casual behavior from the bar. Please keep in mind. Yes, please take down your name.
Johnny L. Tocho.
Heard Mr. Johnny so and so. Also heard MS
Caroline.
Caroline Leonard so and so. Mr. Johnny so and so submits that an objection as regards the maintainability of the revision petition has been filed by the petitioner, by the respondent, which a copy of which has been served to him. He accordingly seeks some accommodation to go through the same and seeks posting the matter for final disposal at the admission stage.
Lordship, yes.
Correct?
Lordship, yes.
Relist Thursday or tomorrow?
Wednesday, Lordship. Thursday, I have a fixed matter.
All right, Wednesday as a fixed matter.
Item 2.
Compensation. Yes.
Your Lordship, I have filed a show cause affidavit on behalf of my, on behalf of respondent number 15 on 22nd May 2025, wherein I have stated that the correction of the award was sent to the concerned department.
Yes,
And
Ms.
the
Mary?
same-
22nd May
22nd May 2025.
20.
25.
Because it appears that there is a judicial order of 22/4/25, Ms. Mary,
Yes, Your Lordship.
where it says that for further time, Ms. Mary so has prayed for further time to file the counter affidavit and submit that she has yet to receive full instruction, that by submitting that positive steps towards the compliance of this court has been taken. However, certain clarification is still required. Now, those clarification has come or not come?
Your Lordship,
Because this order is of 22/4. After this, you find something.
yes, I have filed the affidavit.
Where is that?
My affidavit is filed on 22nd/5/2025.
Second 5, yes. Which para you want to rely?
Your Lordship, we have received the approval of the award that is made by the department on 12 January 2024, which I have highlighted in para number 5 of my, para number 6 of the affidavit.
Yes.
And after the approval is obtained,
So the passes, under the award, the passes of the petitioner were declared as genuine.
yes,
Yes.
yes. Later on, after the approval was obtained from the department, there was a mismatched amount in the award, and correction is requested by the acquiring authority, which is in page number 17, that I reflected in para number 7 of the affidavit. So accordingly,
Para number?
para number 7,
And this letter is at page 17
yes.
of this affidavit.
Yes, and in para number 8, I have mentioned that the correction was made and the same was sent to Land Revenue and Settlement Department for reassessment, and the response to the same is awaited.
Huh?
Para number 8, Your Lordship.
That is submitted that on identifying the discrepancy of the amount, correction was accordingly made. The same was thereafter sent to Land Revenue and Settlement Department for reassessment, and the response in this regard is awaited. So what has happened to the reassessment?
That will have to be answered by the Learned Counsel for the Land Revenue and Settlement.
Who is appearing?
Miss Linda.
Who? Miss Linda. Where is Miss Linda?
No, my lord. She has some personal difficulties today.
Your Lordship, unfortunately, the
Baby.
Mrs. Linda's baby has got COVID-19. So
Has got a
COVID-19,
COVID.
yes.
When?
Day before yesterday, it was found out.
Is he doing okay now?
Yes, my lord.
Yes, Mr. Victor, you want to say something?
Yes, my lord. So far as my knowledge is concerned,
See, I
that
think,
reassessment was already approved by the state government.
correct, I think now only reassessment.
That reassessment was also approved now.
So, but if it has been done, then compliance is done.
BRTF has to make payment, sanction.
Where is BRTF?
My lord,
Ming Sangpui.
yes, my lord, I just received the instruction in the premises of this court this morning, my
What
lord.
is that?
They stated that they received a letter from the state respondent. Then, since various chains of command, it will take some more time for approval of the competent authority. Then I may be given 4 weeks' time for making payment, or
So, no, so I will, now the order, which is the order of the court, because according to Ms. Sangpui, your instructions, 4 weeks' time for payment. This
Yes,
is
my
what
lord.
you just said.
some more time, my lord.
All right, but only thing you see, this court is not an executing
Yes.
court. This is not an executing court. Now, we are only concerned whether the court's orders are being complied, not complied, right? Under the order of this court, Mr. Victor, where do I find?
This is my contempt petition, my lord.
Yes, page please.
Page number 10, 10. The relevant portion is page number 10.
Page number
10.
10.
Para 9 and 10.
1 second.
Yes, my lord.
Operating part,
Para 9 and 10.
page 10. Yes, I have it. Please read.
Prior to sending I'll read from para 8.
Yes,
The
please.
verification team shall, within a period of 2 months from the date of receipt of a certified copy of the order, convene a spot verification of the petitioner's lands. If it is found during the verification that the construction of road connecting Siatlai, Zongling, Kopai, Lucky Village has been made upon the lands of the petitioners, the DC cum District Collector Siaha shall send the verification report to all the other respondents. Prior to sending the verification report by the DC to the other respondents, the respondent number 4 shall take a decision with regard to whether the land passes of the petitioners are valid and genuine passes, after giving an opportunity of hearing to all the concerned parties. If the petitioners' land passes are valid and give heritable and transferable rights to the petitioners, the respondents shall thereafter take a decision whether they want to vacate the petitioners' lands on which the road is constructed or acquire the land. If the respondents decide to acquire the land, they shall initiate proceedings for acquisition of land of the petitioners under the provisions of 2013 Act for the land portion of land it seeks to acquire. The entire exercise for completing the process of acquisition of the petitioner's land or a portion thereof, and the payment of the compensation shall be completed by the respondents within a period of 6 months from the date of sending of the verification report by the DC to the other respondents.
Now, Ms. Mary, the verification report was given when? First of all, Mr. Victor, the order, what is the date of this judgment and order? Please give me the date.
29 May,
This judgment order is dated
6 months, 1 day long.
3/9/2018.
3/9,
2018.
2018, under which 2 months for verification, correct?
Yes, my lord.
Verification, after verification report goes, R4, validity of the passes,
Yes, my lord. That has been
correct?
declared.
I know, validity of the passes, and after that, whether to acquire, not acquire, and if acquires, then compensation, payment, everything to complete within 6 months
Yes, my lord.
from verification. Now, when was the verification report submitted, Ms. Mary?
It's, Your Lordship, 25 September 2018.
25,
25th. Yes, 25th September 2018. 2018.
So it was done within the 2 months given.
It was conducted on 18th September 2018 and report was submitted on 25th.
Correct. So verification is done in terms of the court's order then,
Yes.
right?
Yes.
And then it was found genuine, isn't
It
it?
was not, the problem is that as per the court's order, this honorable court's order, prior to sending, they have to verify the genuinity of the land holdings of the petitioner. So what happened in these cases is that the custodian of the land records, that is the senior revenue officer of MADC, they have lost the register. So not being able to ascertain whether the land are genuine or not, the case could not proceed. So it was put on hold for a very long time. So it was only in the year 2022 that they have made a reconstruction of the passes. And on 2023, in the month of March, the senior revenue officer have requested the respondent number 4, that is the DC Siaha, to accept the reconstructed.
No, that's all right. See, as far as you are concerned, you have done your
Yes.
thing. I am not going into that. I'm just taking down these details so as to give a detailed order right now,
Yes.
only for that. Because what appears is that now only payment has to be done, but if we go by the dates, it appears that there has been some non-compliance. Because payment was ultimately supposed to be completed within 6 months' time
Yes.
from the verification report. That verification report, rightly, wrongly, was given in way back on 25/9/18.
Yes.
Correct?
Yes, correct.
So if there were some problem, one could have also come before the court for seeking extension. The problem arises here where the courts are being taken for granted. This is what is happening. You see, there can be a difficulty, there can be problems in complying with the court's orders. In that situation, an application, an appropriate application can always be filed before the court. But this is never done. Isn't it? This is never done. Mr. Victor?
They have not filed in the application.
Exactly. It's never done. So that is why I use the word granted. And today also, now we are in 25. Payment has not been done till now. The order of the court is way back of 2018. Isn't it? And in your affidavit, where have you given the apology? Where have you, in which paragraph have you tendered your unconditional apology, sorry? And Ms. Sangpui, have you ever filed any affidavit before this court?
My lord, my lord.
You have. So this is why I use the word granted. And why I am telling you people is that you impress upon your own clients that in future one must be more careful. Because this court is not going to remain silent always. This court knows what is to be done to protect the dignity of the court. Correct? So yes, 4 weeks, 6 weeks. Give me your instructions.
My lord, we recently received the award number 1 of 12 of 2024.
Please give the instruction. A copy of the instruction. Yes, court attendant, please take it. Heard Mr. Victor so-and-so, learned counsel appearing for the petitioner. Also heard MS Mary so-and-so, learned counsel appearing for respondent numbers.
4, 8, 10, 13, and 15.
Respondent numbers 4,
8,
8,
10,
10,
13, and 15.
13 and 15. And MS Sangpui, learned counsel appearing for respondent numbers
2, 6, 9, and 12.
2, 6, 9 and 12. And anybody else? And
for the respondent number 14.
And Mr.
Ishida Thangmoya.
So-and-so, learned counsel appearing for respondent number
14.
14.
14.
14. And Mr.
And for respondent number 5.
So-and-so, learned counsel appearing for respondent number
5.
5. The subject matter of the instant contempt petition is the non-compliance of the of this court's judgment and order dated 3/9/2018, passed by this honorable court in WPC number 78 of 2018, wherein this court was pleased to direct verification, spot verification of the petitioner's lands within a period of 2 months from the date of receipt of a certified copy of the said order, and after the report is received and after the report is submitted, comma, directed the other respondents, especially the respondent number 4, to take a decision with regard to the validity and legality of the passes, subject passes, and based on the outcome of the aforesaid exercise, further directed the respondents to take a decision whether they want to vacate the petitioner's land on which the road is constructed or acquire the lands, and in the event the respondents decide to acquire the land, directed the respondents to initiate proceedings for acquisition under the provisions of the right of fair compensation and transparency of land acquisition, rehabilitation and resettlement act 2013. Stop. It is specifically directed, sorry, just delete that part and say, this court further was pleased to direct that the entire exercise for completing the process of acquisition of the petitioner's lands or a portion thereof and the payment of the compensation to be completed within a period of 6 months by the respondents from the date of sending of the verification report by the Deputy Commissioner. Stop. Relevant extract of the said judgment and order is reproduced hereunder for ready reference, quote unquote, A2A, page 10. Reading of the aforesaid extracted portion, it further appears that this court, while making the aforesaid observation and direction, was further pleased to clarify, in view of the fact that 10 years have already elapsed from the time the road was constructed, that in view of the damages caused to the land and crops of the petitioners, even if the verification report indicates that subject road is not constructed upon the lands of the petitioners, comma, the petitioners would have the liberty to make a claim for damages before the civil court as per law. Stop. The affidavit, additional affidavit filed on behalf of the respondent stroke contempt number 15, I SHVL Hirujella Kheng Tai, who is presently working as the Deputy Commissioner, stroke District Collector, Saya District, Saya, Mizoram. Deposed that the verification as directed was completed by his predecessor on 25/9/2018, and after the verification of the land holdings of the petitioner, no, sorry, and, don't say and, however, the original records of the land passes of the petitioner for ascertaining the genuinity of the land was not submitted by the Revenue and Settlement Department, Mara Autonomous District Council. Stop. Accordingly, the records were reconstructed from the Senior Revenue Officer, MADC, which was received on 25/3/2022. Correct, Ms. Mary?
Yes, Your Lordship.
And after receiving the same, the verification of the land holdings of the petitioners was duly done, and by order dated 26/4/2023, his predecessor was pleased to issue order dated 8/5/2023 declaring the passes of the petitioner as genuine as per the request of the Revenue Department, MADC. It further appears that thereafter the matter was sent to the government for further necessary action, and accordingly preliminary notification dated 12/1/2024 was issued by the concerned government department under section 11 of the Act 2013 for acquiring the subject petitioner's land, and thereafter the award number 12 of 2024 was approved by the government on 15/1/2025. It further appears that after the aforesaid award was received, there appeared to be some mismatch as regards the amount mentioned therein as 3 checks were already paid to the petitioner before they approached before this court by filing the connected writ petition, wherein the judgment and order assailed in the contempt petition, non-compliance of which is alleged in the instant contempt petition, has been filed. Thereafter, the discrepancy of the amount was identified and accordingly corrections were made. And the matter was sent to Land Revenue and Settlement Department, Government of Mizoram, for reassessment. Stop. Today, when the matter was called, MS Sangpui, learned counsel, appearing for the respondent,
2692.
submits that she has received an instruction dated 21/7/2025, which indicates that the reassessment has been completed by the concerned department and an amount and an award, and after reassessment this is which department? BRTF. The BRTF stroke they are the acquiring authority.
My lord, this letter was issued by headquarters project chief engineer project principal.
Yes, Mingi, what did you write? After? Don't say BRTF. After reassessment, was completed, the Undersecretary to the Government of Mizoram, Land Revenue and Settlement Department on 29/5/2025 approved the award number 12 of 2024 amounting to rupees 82,48,78,525.27. for the construction of the subject road. Stop. The aforesaid instruction dated 21/7/2025 issued from the office of the chief engineer further indicates that the aforesaid payments is currently under process. Copy of the letter dated 21/7/2025 reads as under. You quote this, huh? Copy of the letter so and so, which is kept on record and marked as X, reads as hereunder, quote unquote. Upon appointed query being asked, MS Sangpui, learned so and so, further submits that she has instruction that the aforesaid payment is likely to be completed by within a period of 6 weeks from today. Stop. It appears that despite the judgment and order of this court way back on 3/9/2018, wherein after completion of verification of the petitioner's land within a period of 2 months, the entire exercise of acquiring the petitioner's land, if need be so, and to make payment accordingly, and to make payment accordingly to the petitioner, was directed to be completed within a period of 6 months from the verification report, from the date of submission of the verification report. Stop. The additional affidavit referred above indicates the timeline in which the verification report / clarification and the award was issued. It appears that the timeline as directed by this court has not been strictly complied with. That apart, no unconditional apology appears to be pleaded or tendered in the affidavit placed before this court on behalf of the contemners. On behalf of the contemner number 15. It further appears that the payment is still not been released to the petitioners, despite their lands having been acquired way back in 2018. Huh?
Yes, my lord.
2018. Without commenting further, this court deems appropriate to post this matter after 6 weeks, and depending on the updated development, by then decide the merit of the contempt petition. Yes, now when you want, relist on such and such date.
Deeply obliged.
Yes, date, Ms. Sangpui. 6 weeks, after 6 weeks.
2nd of September.
2nd September? Mr. Victor? Ms.
Yes,
Mary?
Yes, my lord, 2nd September.
You please tell your respective clients whatever is to be said. The order speaks for itself.
Deeply obliged.
It is sad, Mr. Victor, that your client have been waiting for so long. Yes.
Item 3.
May I please, Your Lordship?
Please, Your
Lordship, I'm appearing.
This contempt matter, Your Lordship,
was filed on April of 2023. So more than 2 years has passed. And Your Lordship, this
Sorry,
is
Mr. Jonathan, what did you say?
This contempt petition has been pending for more than 2 years now, Your Lordship.
2 years.
2 years. It was filed on April of 2023.
But who is this R11, a new incumbent?
Yes, new incumbent. Your Lordship,
Notice has been issued.
It has been, postal tracking has been done, and on 5th of May 2025, R11 have received.
So
the
anyone
notice.
appearing for R11? Anybody appearing for R11? Who is R11?
It is the general manager of the Northeast Frontier Railway.
So I think then we'll keep on another date because the R11 has only been served in the May.
Completed.
In May. We are in
Yes.
July now.
Yes.
Only in May, right?
Right, Your Lordship.
So we'll have it in the month of August. If by then there is no representation, we shall go ahead. I will. Otherwise, I will record today that service is complete.
Yes, madam.
Okay.
And one more thing, Your Lordship, if you kindly allow. R11, the general manager, has replaced respondent number 6, the earlier incumbent. And the earlier incumbent, who was the earlier general manager, has been represented, and he has filed an affidavit. So affidavit has been filed by the erstwhile general manager. Then he has been replaced by the R11. So is it required for R11 to file another affidavit? That's the question.
No, but R11 has to be heard.
Yes.
Now he is the new incumbent,
Yes, ma'am.
isn't it?
Yes.
You have implemented him.
Completed, not to serve.
So that is why.
Yes, ma'am.
It appears from the office note dated 18/6/2025 that the notice sent to the newly implemented respondent number 11 has been delivered to the said respondent on 5/5/2025. However, today on call there is no representation on behalf of the aforesaid respondent number 11.
Lordship, I am appearing on behalf of Sanjay Kumar Methi for respondent number 4 to 6. Lordship, it's the matter on 4th of August.
Then after in the beginning you say heard Mr. Jonathan so and so, learned counsel appearing for the petitioner. Anybody from here appearing for respondents?
No, Your Lordship.
MS, your name?
R.R. Singh.
Huh?
R.R. Singh.
R.R.
R.R. Singh.
Singh.
Rekha Rani Saikya.
R.R. Saikya, learned counsel, is appearing on behalf of Mr. S.K. Medhi for contemptor stroke respondent number 4.
4 to 6.
4 to 6. And after that you say it appears from the office note, and then at the end you say relist on 4/8/2025.
Obliged, Your Lordship.
Item 4.
Obliged.
Please, Milad.
Yes, review.
Please, Milad.
What grounds? Yes, Mr.
Milad.
Dwivedi, what grounds?
Milad, I am on a limited aspect, Milad, and Milad, I am not justifying Milad non-appearance, Milad, before the trial court, and Milad, these facts not being brought before this court at the Milad time of the appeal, Milad. But unfortunately,
Facts not
Milad,
brought. What facts not brought, Mr. Dwivedi?
Milad, that Milad, three Milad, crucial aspects, Milad. First, I had completed the suit pertains to, or there's an allegation that I have illegally encroached their portion of land, and so a suit for vacation and as well as damages was filed. Now by the order, your lordships have the London trial court had directed.
Mr. Dwivedi, have you challenged the trial court order?
Unfortunately, unless the decree.
Because the trial court has already held has declared. The only thing the trial court didn't do is compensate, which this court did. This court has, on the basis of the pleadings, This court found just and reasonable and has done it. Now this is a review, this is not a rehearing. You are aggrieved by this court's order, you can go to higher forums. But this is, if you want to file a review of this court's order, please show that what is the error apparent on the face of the record.
Just three fundamental
You please give us the error, show me the error.
Order 8, Rule 10 says that even if a party does not appear, then also the plaintiff.
You are arguing on merit, Mr. Dwivedi. You are arguing on merit. Review is not a
rehearing. Because I am on a question of law and I am relying upon 2 Supreme Court judgments.
Yes, Supreme Court judgments also says if sometime it cannot, compensation cannot be determined on precise, there cannot be any evidence. In that situation, what is to be done? Just and reasonable. Just and reasonable.
Just and reasonable.
Yes.
I have
so what? Now you see, Mr. Dwivedi, the problem is you may be right in all your legal submissions, but as far as this court is concerned, this court has decided the compensation after applying the principles laid down in the civil procedure court, and whatever is felt to be just and reasonable has been given. Now, if you have any grievance, you are free to agitate in the appropriate forum. But if you come for a review, then you see, you went before the apex court and you came back with a liberty to file a review.
Please, Minister.
You came back with a liberty for filing review. But review has to be on the basis that there is an error. Now you have to show that there is an error apparent. Review cannot be a rehearing, Mr. Dwivedi.
I am on a limited aspect that there was no document or an evidence filed by the plaintiff to show.
Not necessary.
Grant of compensation.
Mr. Dwivedi. And you see, even if you argue that is again on merit. This is before this court, your counsel was there. The respondent counsel was heard. That is why I am repeatedly using the word rehearing, Mr. Dwivedi. You cannot.
May I suggest something? May I suggest something,
Yes.
I am not. I don't want the plaintiff to today suffer by any order. What I am saying, may reopen, direct me to go before both parties to go before trial court.
Why?
Consider these evidence.
No.
Or because today what is happening, 50,000 as compensation per month. I have
rightly done. That is just and reasonable. For so long, you have not compensated. The basis was clearly given in the pleadings. The pleadings clearly indicated how you have occupied and you have.
There is no document whatsoever, There is
Mr. Dwivedi.
May I show 2 documents? Your Lordships may just have page 65 of my review.
Mr. Dwivedi, I have brought one case for you.
Please. In fact, I am relying upon Maya Devi, para 40 and 41 for a minute.
Apex Court case Murlidhar.
Please.
2024 SSC online 3385.
Please,
Paragraph 2. I am reading it for you.
Please,
The concept of just compensation rests on the principle of restitution and integrum, which means restoration to the original condition as far as possible. Taking the person to whom damages are awarded to a position as if the incident, or in this case, the accident, had never occurred. While there is a well-recognized and positive principle of law, we must also recognize its limitation. The award of compensation, however much it may be, does not give back to the person who affected their life, but only elevates the worry of being able to secure the required amenities. In awarding non-pecuniary damages, this court has often highlighted the difficulty in computation, for there is no manner in which such determination lends itself to formulaic keep hearing. every person in life has undertaken certain steps towards the realization of dreams, held goals and aspirations, and when they end up in such an unfortunate situation where, for no fault of theirs, the trajectories of their lives are forever altered. Although abstract in the written word, these factors form a large part of the pain and suffering one undergoes apart from the manifested disability which may be visible to another person. Keeping in view the above referred judgments, the injuries suffered, the pain and suffering caused, and the lifelong nature of the disability afflicted upon the claimant appellant, and the statement of the Dr. S. Reproduced above, we find the request of the claimant appellant to be justified, and as such award so and so under the head pain and suffering, fully conscious of the fact that the prayer of the claimant appellant for enhancement of compensation was by a sum of so and so. We find the compensation to be just, fair and reasonable at the amount so awarded. So that is the basic thing. It is the what is fair, reasonable and just. Now,
unfortunately, in this case, they were seeking plus 50,000 per month without any document being
there is
placed on
another
record.
decision of the Apex Court, which is Construction and Design Services versus Delhi Development Authority. This is 2015, 14 SSC 263. Applying the above principle to the present case, it could certainly be presumed that delay in executing the work resulted in loss for which the respondent was entitled to reasonable compensation. This is for you, Mr. Dwivedi. Evidence of precise amount of loss may not be possible, but in the absence of any evidence by the party committing breach that no loss was suffered by the party complaining of breach, the court has to proceed on guesswork as to the quantum of compensation to be allowed in the given circumstances. Since the respondent also could have led evidence to show the extent of higher amount paid for the work got done or produce any other specific material, but it did not do so, we are of the view that it will be fair to award so and so as reasonable compensation. Now this court, because you have not
Paper book may be prepared. In the meantime, Your Lordship, I have sent the notice to the concerned PS, that is Bonk on PS, and the same is awaited.
Same is awaited.
Yes.
Appellant also and amicus have to be appointed, I think.
Yes, yes.
So we can appoint the amicus.
Yes.
And we can ask the preparation of the paper book in the meantime.
Yes.
Isn't it? This is not admitted. Is it admitted?
No, Your Lordship.
Mr. Victor, are you there? Would you like to be an amicus and assist the court in this criminal appeal?
Yes, my lord.
Heard MS Mary, learned APP for the state respondent.
What is falling from your lordships, I appreciate, the only issue is, in this case, the plaintiff was seeking a rental. It was not a case of compensation.
You see, Mr. Dwivedi, rental or whatever for the losses that he has suffered, and the trial court has given a declaration that you have illegally dispossessed him for that period. Correct? There is a declaration in his favor, but the trial court said no compensation because nothing is available.
Absolutely.
Correct. Now that is where this court interfered, because and this court has given the reasoning.
Please, Mills.
I understand that what you are now trying to argue is that there was nothing on record, no documents to show that this is the loss or this is the rent, correct? But nonetheless, the evidence of the plaintiff was there, which has been taken a note of this by this court, And
In fact, your
whatever-
lordship will, if
whatever
your
this
lordship
court
will just
felt-
have a look
you
at
see,
the evidence.
Whatever this court felt reasonable, this court awarded.
Please.
Now, if there is something, some error, I am not saying my order is beyond any error. Yes,
Please.
we are all human beings, we all have our own perception based on the interpretation of law and our understanding and ability of the law, we give our judgment. Correct? Now, I have done what I thought was just and reasonable. If you have any grievance, of course you know your remedy, but you have come in review. In review, it is limited grounds. That's why I am asking repeatedly, show me the error which is apparent. You don't need such lengthy hearings, arguments to point out that error which has to be
I am only
apparent on
relying
the face
upon
of
Maya
the record.
Devi to show.
All
that-
right, which is that decision, Ms. Fanai? You have a copy?
Yes, my lord.
Plus, my-
We had submitted
my-
the citation.
Which one? Maya Devi.
Please, Mullah. Para 41. In fact, 40, para 40 page.
One sec, let me have a look at the book. Yes, paragraph.
Plus paragraph 40, page 20 of Maya Devi. Plus, may I read?
1 second.
Plus, this is SCC.
I have the
2000
book. I have the book.
Please.
This is 2015 5 SSC.
Please, Mullah.
588.
Please, Mullah.
Paragraph 40 you said.
40, plus.
40.
Please, Mullah.
Yes, read.
Yes. Finally, another aspect which has come to the fore is approach of the trial court in adjudication of the suit. The plain contains an averment that the suit property had already been sold. The defendant Shri Premchand Verma had appeared in the trial court and filed written statement in which, while admitting the documentation executed between the parties, he had denied that he had served any legal notice or set up the defense that he was entitled to forfeit the amount received by him because the plaintiff decree holder had failed to pay the balance sale consideration as envisaged in the deed of agreement for the earnest money. After filing of the written statement, he stopped appearing and the suit proceeded ex parte. Significantly, the deed of agreement for the earnest money as well as the written statement predicated defendant's title on the will, and in this context, there is no evidence on record that it has taken effect because of the death of the testator. In the event as is expected, no appeal against the judgment and decree came to be filed. Therefore, the decision was not tested before or scrutinized by the appellate court. The absence of the defendant does not absolve the trial court from fully satisfying itself of the factual and legal veracity of plaintiff's claim. Nay, this feature of litigation casts a greater responsibility and onerous obligation on the trial court as well as the executing court to fully satisfy that the claim has been proved and substantiated to the hilt by the plaintiff. Reference to such and such will be sufficient. Failure to file a written statement, thereby bringing Order 8 Rule 10 of CPC in operation, or the factum of the defendant having ex parte does not invite a punishment in the form of an automatic decree. Both under Order 8 Rule 10 of CPC and invocation of Order 9, the court is nevertheless duty bound to diligently ensure that the plaint stands proved and prayers therein are worthy of being granted. I am fully satisfied. This is what I am relying upon.
Yes, Mr.
To show-
Trivedi, but in the present case, the plaintiff's evidence is there. If I
Let's have that
believe,
evidence for a
Mr.
minute.
Trivedi,
Just
I have not read the case papers yesterday night. But if I recollect in the judgment that I authored against which you have filed the review, I have
Please.
quoted the evidence of the plaintiff.
Plus, there
Yes.
is nothing
Mr.
as far as
Lalna,
50,000
yes,
is
I think I
concerned.
have. Yes, where
Definitely,
is
my
that?
lord.
Where is that? Which page of the judgment?
Page, let's see.
Plus, appeal page 42.
42.
Appeal.
My lord, the judgment is annexed to the review petition as well, my lord.
Yes, yes.
Starting from A10, the relevant portion.
No, that evidence, where is that evidence? I think I have quoted the evidence if I am not wrong. If I am not wrong, the plaintiff has.
Yes, my lord, page A20.
Page
A20, starting from the index.
A20.
A20, yes.
Paragraph, just tell me the paragraph.
Paragraph 43, my lord, judgment and order.
Paragraph 40?
43.
43. Yes. All right, Mr. Dwivedi, please read from 40.
Please, Mullah. I'll read from 40 plus. First, it appears that where the defendant has not filed written statement, it shall be lawful on the court to pronounce a judgment on the basis of facts contained in the plaint. However, the court may in its discretion require any such facts to be proved. In the present case, the plaintiff in paragraph 9, 10, 9, 11, 12 and 15 have clearly averred that due to deprivation of the plaintiff to utilize, use and develop the subject land, which is his primary source of income, he has been unreasonably and immensely suffering till date. It further appears that the plaintiff has pleaded in the plaint that the plaintiff is entitled to be compensated at rupees 50,000 only per month from the arrears amounting to 52 lakhs only with an interest at the rate of 6% accruing from the illegal and forceful occupancy of the plaintiff's land for a period from January 2012 to August 2020 within a period of 30 days from the date of issuance of the legal notice dated such and such. The said averment stands unrebutted and therefore admitted. Thus, the basis for compensation is available in the plaint. Further, the said basis for compensation having not been rebutted by the plaintiff respondent, it was lawful for the trial court to pronounce the judgment against the defendant / the respondent that apart, the plaintiffs and appellant have deposed during the examination in chief hereunder for ready reference. I, Shri such and such, do hereby solemnly refer that I am the plaintiff in the instant case, that I was allotted a plot of land by Land Revenue and Settlement Department under Section 12 of the LAI Act bearing such and such, covering an area of such and such, thereby providing me all rights, interest arising out of the said landed property to the effect I duly paid revenue taxes to the concerned authority till date, that on such and such the Land Revenue and Settlement Department of Government of Mizoram issued notification for acquisition of private land under Section 4 of the Land Acquisition Act, wide memo number such and such for construction of a new 2-lane highway from NH 54 near Longthalai to Indo-Myanmar border in Mizoram to support Kandal Multimodal Transport Project Phase 1 under SAR DPNI, and subsequently on dated such and such a declaration was made under Section 6 of the said Act, wide memo number such and such. The Deputy Commissioner Longthalai district, wide memo number such and such, issued notice to the person interested under Section 9 of the Land Acquisition Act stating that the government intention to take possession of the said land and claim to compensation for all interest in such land may be made to the concerned authorities, but my land was excluded from the beneficiaries of the said acquisition. That from the execution of above mentioned project, Mizoram State Government represented by Public Works Department, Government of Mizoram issued notice inviting tenders for construction of the said project. To this effect, defendant number 1 and 2 and the Government of Mizoram had signed a contract agreement MOU, and as such the Government of Mizoram issued work order for execution of the said work in favor of defendant number 1 and 2. Accordingly, defendant number 1 and 2 had started execution of the said work on such and such by deploying machinery tools as well as sufficient manpower. In the course of execution of the said work, the defendant number 1 started establishing camps and continued to settle in my said land without taking prior permission and consent from me with effect from Jan 2012 till date. The defendant number 1 and 2 have forcefully and illegally occupied 1400 square feet of my land, admeasuring such and such plus of my land bearing such and such, having an area of 50,000 square meter, and 4 houses including 1 reservoir were also constructed by thereupon by defendant number 1 and 2 without the permission and consent from me. The defendant number 1 also used my land for the purposes of depositing and stocking unwanted soil, debris, sand till date, making it suitable for the agriculture and residential purposes without prior permission and consent from me. That as a result of illegal forceful
This is important.
occupation.
This is
Please,
very
please.
important.
Please, I'll read. That as a result of illegal and forceful occupation of my landed property by the defendant number 1 and 2, I could not utilize and develop my land, which is my primary source of income, and I had unreasonably and immensely suffering from the actions of defendant number 1 and 2 till date. And I personally requested and approached defendant number 1 and 2 repeatedly and continuously to make a negotiation as well as to pay rental compensation in connection with my said land, but to no avail. Plus last, that I have also served legal notice such and such, directing them to pay rental compensation for the illegal occupancy of my land, but to no avail. As a result, I have no option but to approach this honorable court. Plus, what I am submitting
read page 44, para 44. Para 44.
Thus, the plaintiff has put and established his claim for compensation against the defendant number 1 and 2 for illegal occupation of his subject land. However, the trial court, having not granted compensation to the plaintiff/appellant despite holding the right title over the subject land in favor of the plaintiff and declaring that the plaintiff/appellant as a legal owner over the subject land and infringement by the defendant/respondent thereof committed manifest and palpable error, and as such the judgment dated and order dated such and such to the extent warrant interference from this honorable court. As such, the order dated such and such is set aside, and accordingly the findings of the trial court to the extent that the plaintiff is not entitled to compensation as such against such illegal forceful occupation of defendant stands reversed. Resultantly, I direct defendant number 1 and 2 to pay compensation of rupees 50,000 per month henceforth, and also pay arrears amounting to such and such only with interest from the date of illegal and forceful occupation till
So
it is
now
vacated.
you tell me, Mr. Dwivedi,
Please.
how do you want this court to apply the ratio of Mala Devi, right? Mala Devi's
Please,
case? Because
Please,
in the facts of this case, the plaintiff has also adduced his evidence.
Yes.
And this court has said that he has proved his compensation by adducing evidence. This court has not automatically granted the compensation merely by reading the plaint. This is not the approach that has been adopted by this court while granting the compensation. There has been no automatic decree of compensation awarded merely because there was it was an ex parte. You see,
May I respectfully
I understand what you are saying, but that is now on merit.
Unfortunately,
If suppose Mr. Dwivedi, this was a case where without looking in, there was no evidence, only by reading the plaint in one line, this court would have just granted the compensation. Maybe you had a ground for review by showing this decision of the apex court. But that is not so, Mr. Dwivedi.
That is why I suggested that
you want the matter to go back. You want the suffering of the plaintiff to linger. You don't want to make payments for the illegal deprivation of the petitioner from enjoying his own land.
Unfortunately, to my thing, I am not there. In fact, I have a completion certificate way back in 2023. I have produced with the review document.
Mr. Dwivedi, you ought to have challenged the trial court's order then. The declaration.
May I say, with respect, till the time your lordships consider this review, I cannot go to the trial court order, because there is a order of decree by this honorable court. I will take those steps, and that is what I suggested.
No, I am not interested. I am not going to go on all that. I am disposing this review
May
right
I
away.
suggest, in fairness, to all parties, may I suggest, I am ready to deposit the amount before the trial court to secure the rights of the plaintiff, but let these documents and permit parties to adduce evidence to show my case is just have one document with the review page 72. Just because it is not my document, the state of Mizoram has issued me a completion certificate whereby they say I have vacated the property, completed the project in June 23, and this order is passed in 24. That is I am saying it requires review. I had vacated when this order was passed.
Yes, Mr. Lalram.
My lord, in that regard, your lordship, one crucial point is that at the time of filing of the appeal, and despite the learned trial court's decision that the review petition is liable to pay compensation, and they knew that, but even then, your lordship, despite that, they never challenged the learned trial court's judgment and order. Although it was dismissed eventually, my lord, but the liability was still there even at that time. And those documents which they have produced at this stage were not part of the pleadings. They even had not filed the pleading before the learned trial court as well. So under the guise of the review, it is not permitted to re-agitate and re-argue, my lord, what this honorable court had already addressed to regarding the law points, and the reasons had already been given clearly, as we have just read out, my lord. So there is no point for filing of the review. Maintainability also I am challenging, my lord.
Just for one curious, because of the curiosity right now which is coming to the mind of the court on the basis of what is happening, your submissions, one question,
Please,
Mr. Dwivedi.
Please, brother.
What, according to you, would have been a just compensation in this case?
Just to show that I have annexed one document with the review, just have page number 65, which is a lease agreement. Because if I can enter into a lease agreement with other owners, I could have entered. If I had to acquire, encroach their land, I could have taken it legally. Just have page 65. It is a land lease agreement entered by the company with another farmer or the allotee, and just see what is the compensation, the rent.
This land is how much? What is the size of this land?
Your lordships in the order
given,
said I am in encroachment.
No, in 65, page 65.
Please,
What is the area of the land?
I will have to come back because this does not specify.
It doesn't say 10,000, but it doesn't say what is the land and all that. Nothing, no details. It's a very vague.
Absolutely.
Anyway,
but I can come back.
In other words, you are saying not 50,000 but 10,000.
That precisely, and in fact, your lordships are appreciated in the order that I was not in encroachment of entire 50,000. It was 1,400
Mr.
square
Lalramenga, what was that area? I remember, I think I mentioned in that order.
Yes, my lord.
1,400 square meters.
How much?
1,400.
How much?
Just 1,400 minutes. 1,400 square meters. Just have the para 41 of the order minutes. I just read out that. So I was not entirely in possession of the 50,000 land allotted to.
What was the entire land?
Entire land area is, my lord,
50,000
square meters.
Please, no.
50,000
So not even half.
square meters. 50,000 square meter means it will be total how much acre?
In acres, I'll just tell what 50,000 will be. What's this will be 12.35 acres.
12.35.
50,000 will be 12.35 acres, approximately. and plus 1400 square meters will be in acres 0.34. And this is what the plaintiff has said, that I am not in encroachment of entire land. Just have the very paragraph or the evidence that your lordships have recorded in the order. And plus I appreciate, in fact, today I don't want that with a decree in favor that there'll be an unjust enrichment or he will be delayed. That is why I am suggesting I will deposit. Let these facts be tested. Because even the plaintiff did not disclose that I have vacated in June 23.
At page A21, it is in the evidence it was mentioned, my lord.
What is mentioned?
1400 square meters.
Yes.
Was occupied.
Mr. Lalremenga, can you read paragraph 26 at page 37 for the benefit of all of us?
Page, my lord?
37.
Yes, my lord.
Para 26.
Of the review petition, my lord.
Yes.
Para 26.
Yes.
Para 8 of the trial court judgment is reproduced here under for ready reference. The plaintiff had exhibited his land document and his witness has also stated that the plaintiff owned a particular land and the defendants number 1 and 2 illegally occupied the land, thereby infringing the rights of the plaintiff. The plaintiff is entitled to sort for his right. Thus, the plaintiff succeeded in establishing the first 3 conditions. However, the consequential relief prayed by the plaintiff is for rental compensation at the rate of rupees 50,000 only per month, which shall be effective from January 2012, and also to pay the arrear amounting to rupees 54,50,000 only with an interest at the rate of 6% per annum accruing from the illegal and forceful occupation of the plaintiff's land. The plaintiff did not produce any documentary proof to reveal that there is a rental agreement between the parties. There is no basis for computing the amount claimed by the plaintiff. There is no relationship of landlord and tenant between the parties for the plaintiff to claim for rental compensation. Thus, the plaintiff failed to fulfill the last condition to enable an order of declaration. As such, I am of the considered view that the plaintiff has not established his case with any oral or documentary evidence. Therefore, the instance suit is dismissed.
Mr. Lalremenga, this 50,000 is only mentioned in the plaint.
In the plaint.
In the plaint. And anything otherwise, no. It just, which is the paragraph in the plaint? Do you have a copy of the plaint right now?
My lord, now memo of appeal is not annexed to the review
That's right.
petition.
So do you have a copy?
Yes, my lord.
Sure.
I have the paper book, my lord. Yes, my lord. Sorry, your lordship. The plaint copy. Yes. Yes.
So this area that is 54 lakhs 50,000 is for that particular period.
Yes, my lord. Starting from 2012.
Para 11.
Yes.
This legal notice is also a part of this. The annexure 7, no, annexure 5. I think it's there.
Yes, annexure 5.
I am yet to decide,
Please, my lord.
but I take that the arguments are completed.
Please,
Now,
my lord.
suppose we bring down the compensation
Please, my lord.
to 25,000. Would that be agreeable to both parties?
Let me take instructions from the client. May have it next week or 3 days, not more than that.
No, Thursday.
Mhm.
I want to
Absolutely,
finish
what
this case
your
before I
lordship says.
leave the station.
Absolutely. Thursday is fine.
It's
I am yet to decide. I am letting it. I'm making it very clear.
Absolutely.
I am just trying to think and explore if there are.
it may come up again tomorrow, my lord.
Tomorrow also it can.
Yes.
Or
Because
Thursday.
Wednesday, if
In the
possible,
meantime, I'll speak to the client also.
Tomorrow?
because Wednesday, if possible, that much.
All right, Wednesday?
Wednesday, my lord.
Wednesday.
So grateful.
But
Mr.
I am taking the arguments to be completed. Huh?
Yes.
Please.
And I am not recording this. I just want to, because you see, I am definitely not sending this matter back. I am not going to do that.
And my lord, I may...
That is absolutely unjustified. It is a fact that there is a declaration in favor of the plaintiff. When that declaration is there, it only means that his land has been illegally been deprived from him to use it. If that be so, he has to be compensated. It cannot be that he will not be compensated.
My case is there is no encroachment, but I take
No,
what
that all that
what's for me.
now it's too late in the day for us to go into all that. What has
Something,
happened
may I
has
suggest
happened.
something plus?
So
May I suggest
you have also
one-
not taken appropriate steps to take care of those situations. Now it's too late.
My lord,
The lawyer
But
non-dependent
because
was-
of all that, now somebody cannot go on suffering. So
Absolutely. Look, may I suggest one more
there is
thing?
one way I am feeling the matter can also be settled is if both parties agreeable at a particular figure, then maybe we can think of.
Please, absolutely.
But I am also not sure. I might.
May I suggest one
Because the
more
review,
thing?
the maintainability is another aspect which I kept open. Let me think, and I am also giving an opportunity to both of you to get back.
Please.
With this understanding, now the matter is going to be posted on Thursday.
Because may I just say one last thing, look. Your lordships may also subject if that the trial court proceedings may be completed in a time bound manner if your lordships consider because
No,
all this
I
needs to
strongly
be
object, my
tested.
lord.
No. That I am not doing, Mr. Dwivedi, because I don't find that there is any merit in this review.
Plus, I'll take my
But
chances.
I'm sure if I dismiss the review here, the matter may not end here.
My lord, may
Sorry.
I rely
Correct.
on... My lord, may I rely on...
Now, I'm trying to see a situation where perhaps we can conclusively put an end to the matter.
Please.
With the good office of both of you, speak to your clients,
My lord.
Please.
find out,
Please.
and get back on Wednesday.
Wednesday.
Yes,
My lord, may I rely on only two judgments?
Yes.
This regarding maintainability.
yes.
I'll mention the relevant para only, my lord.
Have you given?
Yes, your lordship. The first one is 2024-2 SCC 362.
Have you, is there a photocopy of this? No. Okay, no need. It's all right. I will retain this book then. Okay? This is like petition. Yes, which paragraph, Mr. Lalramenga?
2024-2 SCC 362, para 10,
24.
2024, yes.
Yes,
Para 10, 11, 12, 14, 16 to 16.7.
14 and then 16?
Yes, 16 to 16.7.
Yes.
And the other one, my lord, 2022-17 SCC 255.
This is on review.
Yes, maintainability of review. 2022, my lord, para
Yes.
20 to 24 and 26.
All right. Arguments completed. Repost on Wednesday, give the date as a fixed item for further hearing.
So much.
So grateful, so grateful for the indulgence.
All right.
For orders, item number 6 and 7.
I need this file. So, you give the file and you list it by way of a slip. Okay. 6. Yes, extension, some explanation was supposed to be given. Yes, Mr. Kayal, are you appearing in this matter?
Lordship, in this case, I'm in item number 6. I'm appearing for respondent number 11.
Yes.
Home Secretary.
Yes.
Lordship, today I have been informed that he has been retired. New person has been joined as a Home Secretary. Lordship.
Sorry.
Earlier, Mr. Ajay Kumar Bhala was implemented as a respondent.
He has been now. He's retired.
No, he has retired and posted as the governor of Manipur. And in his place, new.
He's become the governor of Manipur.
Yes, Lordship.
Okay. And who has joined in his place?
One Govind Mohan is joined. Lordship.
As he's now respondent.
He has not been implemented.
No. The earlier person is respondent number.
In item number 6, he was a respondent number 11.
Respondent number?
11.
11.
Yes, Lordship.
R11. And in 7?
7, Lordship.
Mr. Victor, in 7?
10 and 12.
In 7, he's 10.
No, my lord.
10, Lordship.
No. In 7, his respondent number 15. Notice was completed.
15.
Yes.
And
Mr.
in,
Govind
and,
Mohan.
and in 2? In 7?
As I just mentioned, 7 is his respondent number 15.
Sorry. I am getting confused, Mr. Lal Fakwama. And in item 6? 11?
11 is the Mr. Ajay Kumar Bala.
So 11.
11.
All right. Now, I think before proceeding further, you will first have to bring the new incumbent because it's a contempt matter.
Yes, my lord.
You do the needful. You have heard Mr. Kayal, and thereafter we will proceed.
Yes, my lord.
But the contemners are just because they have been transferred out doesn't mean that they shall be automatically released. So, if anything is to be done on the part of the respondent contemner, then that should at least be done in the sense like if there has to be an affidavit filed, you should have get that affidavit filed. I'm making it clear.
Lords.
My lord, if I may. So far as item number 6 is concerned, my lord. As for the respondent number 15, Edikat was already received back and...
Sorry?
As for the respondent number 15, as per the last course order, my lord.
15 is different.
It's different, my lord. What I'm submitting is that the Edikat is now duly served and returned.
Or is received. And 15 is also retired?
No, my lord.
15, anybody appearing? No. All right. Heard Mr. Victor so-and-so, learned counsel appearing for the petitioner. Also heard Mr. S.A. Kayal, learned counsel appearing for contemner stroke respondent number?
Earlier he was 11, item number 6.
Number 11 in contempt case C7 of 2016 and respondent number 15 in contempt case C3 of 2014. Also heard Mr. Lal Ramenga, Learned Counsel appearing for contemner stroke respondent number?
9, my lord.
Number 9. In both?
In both.
9. And Victor is in the first contempt case, that is 7 of 16, and Mr. Lal Fakwama is in the second contempt case, that is 3 of 14. Correct?
Correct, my lord. But may I make one small submission in item 7, my lord? In item 7, there is no such difficulty as the new incumbent is already impleaded. He was impleaded via order dated 4/6/2025. AD card is also duly
anyway,
received.
one second, because here now both the contempt are connected, isn't it?
Yes, Judge.
They are similar,
Just
in
one
fact,
second.
but not exactly the same.
Yes, 1 second. Office note dated 2/7/2025 in contempt case 7 of 2016 indicates that the service in respect of respondent number 15 stands completed. It is Mr. S.A. Kayal, learned counsel, appearing for respondent number 11 in the aforesaid contempt petition, submits that he has that the respondent contemptor number 11 has been transferred and
So he retired and posted
has
in
been retired in the meantime has been retired and has been appointed, no?
Yes, Lord.
Appointed as the governor of
Manipur.
the state of Manipur. He further submits that in the post hold by the respondent number 11 stroke contempt, respondent stroke contemptor number 11, a new incumbent has joined. Stop.
Notes.
That being so, Mr. Victor so-and-so seeks 1 week time to do the needful in order to bring the new incumbent on record. Prayer is allowed, relist on
29th.
on 29 so and so. Now this you segregate both the orders, huh? This order you put in the first contempt case. So and the don't mention about Mr. Lalfa Kwama in the first order. In the second order now you say Mr. Lalfa Kwama, and here that means here he is already, the new incumbent has already been impleaded.
Lordship. Lordship, I can file wakalatnama in his favor also.
Okay. In the second case, you say that heard Mr. Lalfa Kwama so and so, also heard Mr. S.E. Kayal, Leonard so and so, and Mr. Lalramenga, Leonard so and so, appearing for the respective contemners respondents. Mr. Kayal seeks a short accommodation submits that he has also in the meantime received instruction to appear on behalf of the newly impleaded respondent number 15 and accordingly seeks a short accommodation to file power on his behalf. Correct? NDPS 21C.
Yes.
Yes.
An application for bail, my lord.
Yes.
Yes, may I with your kind permission, my lord. The brief fact of the present case is that on 22/11/2022 at 2:40 p.m. a written FIR was submitted at by S.I. Lalsangdera of Zone 1 to the effect that on the same day, that on 21/11/2022 at 11:45 p.m. verbal information was received from a reliable person who said that
Where?
Yes.
Page.
Page number 25 is the brief fact.
Page number?
25 of my petition.
This is the charge sheet.
Yes, charge sheet.
Yes. FIR is dated?
On 22/11/2022.
22/11/22.
And
And charge sheet is dated 12/5/23. And trial started?
Trial started at, as far as my information, 15 witnesses have been examined.
15 out of?
26 witnesses.
Out of 26?
Yes.
So that means there is a balance of how many more?
9.
9 or more.
Sorry.
Huh? No.
8, 15.
You are equally bad. I am very bad in maths.
26 out of 15.
Huh?
Let me.
Okay. You give this. Now, out of the, anyway, first let's see the case and then show me if any of these people have implicated you. Yes. So that means you are in jail since how many years?
933 days.
That is? How many years? Why you don't have the...
I have calculated the days.
Miss Mary?
Yes.
That would be how many years? 2 years?
Yes.
No, almost 3 years, I think.
It is 2.5 years, my lord.
2003, 2004.
Should be more than that.
2004. Your Lordship, counting from 21/11/2022, it's 2 years, 8 months exact.
All right. Thank you. Yes, page 25.
Yes. Then the suspected, the seized article in this present case.
No, read the prosecution story.
Yes. The prosecution story of the case in brief is that on 22/11/2022 at 2:40 p.m. a written FIR was submitted by S.I. Lalsang Bera, Sons of Rohingya and Asylum of Zaunuam OP, to the effect that on the same day, that is dated 21/11/2022 at 11:45 p.m. verbal information was received from a reliable person who said that same evening he saw one Mexicab sumo stopping on the roadside along MZU Road, until about 300 meters before reaching 6 Miles restaurant from Ramricon site. And then some persons, presumably the driver and one passenger, got out of the vehicle carrying some parcels and suspiciously disposed of the parcels among the bushes about 12 meters from down the main road nearby Jumhat. Thus, S.I. Lalsang Bera and party proceeded to the spot. On being led by the informant, as reported, parcels were highly suspected to contain contraband drugs. On reaching the spot, arrangement of 2 civilian witnesses were made, and search was conducted, and they found a suspicious parcel hidden in the bushes about 7 meters down from the Jumhat, located on the side of the main road. The parcel is a large multicolored cloth, mainly purple and yellow, woven into a sack, and upon reaching it in the presence of the civilian witnesses, it was found that the sack contained 22 black polythene parcels tightly wrapped with brown adhesive tape. Each of the 21 parcels contained 10 plastic soap cases, and 1 parcel contains 5 plastic soap cases, with a total of 215 soap cases, which all contain transparent packets with brown powder suspected to be heroin. The same 215 plastic soap cases containing powder suspected to be heroin were seized at the spot in the presence of witnesses by preparing seizure memo. Weighing of the seized suspected heroin was done, and the total weight is 2.760 kgs, with an estimated value of rupees 53,75,000 in local smuggling rate and rupees 13 crore and 80 lakhs in international market rate. Its plastic soap cases were marked as A1 to A20.
So you are the person from whom this has been taken?
No, my lord.
Who are you?
Actually, I am the secret informer. So I was made accused by the prosecution.
You are the informant?
Yes.
And anything possessed from you? No.
Not from my possession, yes.
Yes, Miss Mary?
Your Lordship, the fact is that the petitioner, the present petitioner, in fact, is the informant in this case. What happened is that he and his girlfriend at that point of time has got into this kind of business, narcotic business, and then he suddenly decided that it's enough, and then he want to report the same, and then he went to the police station, and it was from his own statement that recovery was made, and now evidence is already taken, and the petitioner application was made to make the petitioner as I forgot the word.
Accused.
Approval for the prosecution, but then it was declined by the learned trial court. But then his involvement in the case is very clear from the evidence adduced also. But then the only thing is that he's the one who informed the.
He's one the informed, and plus he's been in custody for more than 2 years.
Yes.
There are 26 witnesses, only 15 till now has been examined.
So prosecution has submitted an application to make him as an approver, which was duly rejected. I don't know the reason stated for the rejection order. So I'll leave it to your wisdom, Your Lordship.
I mean, in view of because those cases are there.
Long incarceration, yes, okay.
Because in that situation, that statutory restriction shall not come. And so far, those 15 witnesses that has been examined, has they said anything about him?
Yes.
They have. What is that they have said?
Your Lordship, if I may take Your Lordship kind attention to page number 218. This is witness number 10. 218. I believe this is the second last page of the petition.
Yes.
Second last page, paragraph number 6. This is the examination in chief of respondent.
Yes.
PW number 10. Para 6.
Yes.
In the year 2022, accused Lalun Sangi is the girlfriend.
He is the petitioner?
Yes. Lalun Sangi, the first name is the girlfriend, which I mentioned.
Okay.
And Evlal Numpuya, the present applicant, came to our place and told me that they are planning to keep some materials nearby our house. On that day, they took out some articles from a plastic stool chairs. The said articles were wrapped in so and so. Next paragraph. On that day, the accused Lalun Sangi and so thrown away some plastic stools and chairs and were torn up by them when they took out some articles from the plastic stools and
So materials are there.
Yes, it is there, and he has already admitted it was on his own. It was from his own volition.
Where is that?
He's not examined yet, but then it is in the 164, 161 statement. Sorry, 164 statement, which is in page number 163. The relevant portion English translation is in page 166A. 166A. 166A.
166.
Yes, A. It's numbered A and B. So.
Yes, I've got it.
Yes. So this is the English translation.
Yes.
So basically what he have stated here is that he have this girlfriend, and his girlfriend and him used to transport heroin, and then they kept it in near the witness number 10's house, and then they throw it in the nearby.
But this apart, no criminal antecedent against him, right?
Yeah, from the record, yes.
He says, I told Lalsun Sungi what she was doing was wrong and warned her to stop.
Yes. In page number 166B, he said that went to Vivacon police station and reported everything. And it was from his So this is in,
In the peculiarity of the facts, I think,
yes,
and considering the delay.
okay. Sorry. But, Your
Yes.
Worship, my only prayer is that since they are co-accused, this should not be made precedent, because precedent
No.
for the other cases.
Will I be able to finish the dictation? I'm going to dispose. What's the time?
3 minutes left.
Huh?
3 minutes left before lunch.
Okay, then at 2 and till then let me reflect. I haven't decided. It's a very old saying. Till a judge doesn't
Put a signature.
put his signature, you don't know. Because we keep thinking, like you must have heard, a lawyer's mind never sleeps. It applies to this side also.
Yes.
Mr. Sinha, I am in midst of one bail petition. I'll just give the judgment and then there is another bail and then I shall take up yours. So you please wait. Which page is the FIR?
Page number 123.
1,
1, 2, 3.
1, 2, 3. Yes. You are number 2. You are what is the name of the accused person?
Yes.
At page 123, which one is you? The petitioner?
Yes, I'm the petitioner then.
No, which one? Lalin Khuma or Lalduang Liana?
Lalnun Puya.
Huh?
F. Lalnun Puya.
That is number 1. No, you showed oh sorry, I am in 128. Page 123.
Yes.
No, I'm a bit confused. This page 123 is a report of Caesar. Where is that FIR on the basis of which this, because Ms. Mary said that you were the informant, you filed an FIR. Which is that FIR?
The formal FIR is not available.
And when were you arrested? Where is that? Where do I find that? Which document?
There are two arrest form.
Yes.
In respect of the applicant.
Yes.
The first one is in page number 47.
47.
Yes.
F. Lanan Pui. That is you.
F. London Puya.
That is you.
Yes.
So this arrest was on
In
12/11/22.
according to this, it is on 26/11/22.
20?
22.
Where? Oh, yes, 26/11/22.
But as per page number 62, which is another arrest.
Which one is correct, Miss Mary?
Your Lordship, the correct date should be 22/11/2022.
All right, so that is page 62.
Yes.
Yes. Heard, Mr.
Lalpi and Fela Chongkru.
Learned Counsel appearing for the petitioner. Stop. Also heard MS Mary, Learned APP for the state respondent. By way of this application under section 483 BNSS, read with section 37 of NDPS Act so and so, comma, the petitioner, i.e. F. London Puya
Yes.
is
Puya.
seeking grant of bail in connection with session registration number 185/2023 arising out of Vivacon PS case number 410/22 dated 22/11/2022, registered under section 21C, read with section 28 and 29 of the NDPS Act so and so. The brief facts of the case is that the petitioner was arrested at Tandril, Mizoram on 22/11/2022 with other.
I'm sorry, Your Lordship, it should be 26.
26?
Because that is the day when they were taken into custody.
26?
Yes.
26/11/2022 with other accused persons in connection with the aforesaid Vivacam PS case for his alleged involvement with respect to seizure of 2.760 kgs of heroin. And since then, he has been detained at Central Jail. Don't say detained, he has been in custody since, and since then he has been in custody till date. Stop. Mr. So-and-so learned counsel appearing for the petitioner submits that the petitioner has been languishing in jail for almost last 2 years, 8 months, and the trial is unlikely to conclude soon. He further submits that the petitioner being the informant on the basis of which being the informant of the alleged involvement of his girlfriend stroke accused stroke, give the name,
Lalun Sangi.
so and so, the police authorities has wrongly framed him in the case in hand. He further submits that since the trial is unlikely to be concluded soon, in view of the fact that the accused petitioner has been languishing in the jail for last so many years, his right under Article 21 of the Constitution of India has been grossly violated. He accordingly submits that the petitioner ought to be released. Per contra, Ms. Mary so-and-so submits that it appears from the statement as well as from the statement given by the accused petitioner before the investigating officer, as well as his statement recorded under section 164 CRPC, that he is involved along with his girlfriend stroke co-accused for the sale of contraband articles. She accordingly submits that it is evident from the aforesaid statement that the accused petitioner has confessed his involvement, and hence there are reasonable grounds of the accused petitioner being held guilty for committing an offense under section 21C of the NDPS Act, read with the other sections as charged. She accordingly submits that in view of the rigors of section 37 of the NDPS Act so and so, the accused petitioner ought not to be released. Right?
Yes.
Heard, perused. It appears that on 21/11/2022, upon an information being received this I can say from the accused petitioner,
Yes.
From the accused petitioner.
From the disclosure statement of the...
Huh?
yes.
From?
From the accused petitioner, it's correct, Your Lordship.
No, I want to say that the prosecution received an information from a reliable person. So that reliable person is the accused petitioner?
Yes, yes.
Admittedly?
correct. Yes, admittedly.
OP, what did you write? Upon an information received from the accused petitioner stating that he saw one maxi cab within bracket sumo stopping on the roadside along MZU Road, Tunhill, within bracket about 300 meters before reaching 6 Miles Restaurant from Ramrikon side, and the driver and one passenger carrying some parcels disposed of the parcels among the bushes about 12 meters from the main road. A search operation was conducted wherein I think this is very difficult when you do not write the facts properly.
Yes.
Seeing the maxi cab and these two people, this the information the police personnel is telling, or this is the FIR. See page 23 of the petition. It's so I want to dispose of the petition. Facts are not coming properly.
Yes, my lord. May I kindly bring you to page number 25. There is a charge sheet. Then the brief facts is written there.
Okay. Accordingly, the police personnel proceeded to the spot on being led by the accused petitioner, and upon reaching the spot and conducting a search, they found a suspicious parcel hidden in the bushes about 7 meters down from the Joom hut located on the side of the main road. Upon opening the same, it was found that the sack contained 22 black polythene parcels tightly wrapped with brown adhesive tape, and each of the parcels, 21 parcels, contains 10 plastic soap cases, and one parcel contains 5 plastic soap cases, with a total of 215 soap cases, which all contain transparent packets with brown powder suspected to be heroin. Accordingly, the same was seized, and upon weighing, the total weight appeared to be 2.760 kgs, with an estimated value of rupees 53,75,000. in local smuggling rate and rupees 1380,000 in international market rate. Accordingly, investigation was Accordingly, the two persons were immediately apprehended, from whom the two persons traveling in the Maxi cab was apprehended.
Your Lordship, they were, as written here, they were formally arrested only on 26/11.
Okay, then don't say that. Thereafter, investigation was conducted, and after examining and recording statement, where are the about the arrest they have mentioned?
Your Lordship, on page 26, the last paragraph.
During investigation.
Yes, during investigation,
And
three
thereafter,
persons.
3 persons, including the accused petitioner, right,
Yes,
Yes.
was arrested,
were arrested.
as they were suspected to be, was arrested on,
Were placed in police custody first.
were placed in police custody. No, it says were arrested.
Yes, on formally arrested on 26.
Were arrested on 22/11/2022.
Your Lordship,
and
26/11.
and thereafter, they were forwarded for remand
Yes.
on 23/11/2022, and after the same was allowed, they were thoroughly interrogated, and thereafter, on 26/11/2022,
Yes.
the 3 suspected persons, including the accused petitioner, were formally arrested in the instant case. After informing them the ground of their arrest. It appears that after completion of investigation, charge sheet was submitted on 12/5/2023, and thereafter the trial commenced, wherein out of the 26 witnesses, only 15 witnesses has been examined till date.
Yes, and 11 prosecution witnesses.
Thus, 11 prosecution witnesses appears to be still not examined. It further appears that there is no adverse criminal antecedent. It further appears that the petitioner, accused petitioner has been behind the bar for more than 2 years, 8 months from the date of his arrest, and considering the speed and considering the number of witnesses out of the total 26 witnesses the trial court has examined till date, it appears that the trial is moving in a snail's pace. Stop. Thus, it cannot be denied that the prosecution needs a considerable period for completion of the trial. Thus, at this stage. That apart, there is no adverse criminal antecedent against the accused petitioner. It is worthwhile to mention that a reading of the 164 statement of the accused petitioner recorded before the judicial jurisdictional magistrate, it appears that he has clearly admitted that the co-accused one of the co-accused who was his girlfriend was involved in the smuggling and sale of heroin, and after he realized that she is doing a wrong act, he complained about the same. Then you write. This is required or not required?
Your Lordship, not totally required, and the factual situation is that it is not only that the girlfriend is involved, they are involved.
That has come.
Yes.
But you see, because of the delay now, that statutory restriction.
Yes.
Undoubtedly, the involvement of the accused petitioner from his own testimony, from his own statement recorded both before the police officer during interrogation as well as before the judicial magistrate indicates that he has admitted his involvement in the alleged offense. However, considering that he has been in custody for more than 2 years, the prolonged incarceration militates against the most precious fundamental right do it like this. However, please read it. However, please take your seat, Mary. OP, I couldn't hear anything. Comma. The prolonged incarceration violates the accused petitioner's fundamental right guaranteed under Article 21 of the Constitution. And that being so, the statutory restriction as contained under Section 37 of the NDPS Act, so and so, for grant of bail in case where there are reasonable grounds to believe that the accused petitioner is guilty of the offence alleged, shall not be applicable. Apt to refer to the decision of the Apex Court in the case of Robi Prakash, so and so, reported in 2023 SSE Online Supreme Court 1109, wherein the Apex Court has clearly laid down, clearly held that prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b)(2) of the NDPS Act. Paragraph 4 of the aforesaid judgment reads as hereunder. In the facts of the instant case, as already stated above, the accused petitioner has already spent more than 2 years in custody, and the trial is proceeding at a snail's pace, and hence the fundamental right of the accused petitioner under Article 21 of the Constitution of India is clearly violated. That being so, the accused petitioner, namely so and so, shall be released on bail in connection with so and so case on furnishing bail bond of rupees 50,000 with 2 local sureties of like amount, provided that one surety has to be a government servant. 2 local sureties or no need?
It's all right, yes, Your Lordship.
To the satisfaction of the learned?
The learned trial court, the learned special judge.
Learned special judge?
NDPS Act.
NDPS Act,
Aizawl, yes.
Mizoram, subject to the following conditions, 1, 2, 3, 4. Accordingly, bail application stands disposed of.
Your Lordship, may I make just one prayer? In the ratio decidendi, in the ratio decidendi, if it can be added along with the 2 years, 8 months, more than 2 years, 8 months incarceration, and the fact that there are another 11 witnesses yet to be examined, because the ratio will be only be taken for precedence.
No, you see, that would depend on the facts of each case.
Yes.
Now, it is needless to be, just see if this will help.
Yes, yes.
It is needless to be clarified that there cannot be a fixed number of years.
Yes, okay.
As the yardstick for determining the prolonged incarceration period, as each case would depend on the facts and circumstances of that case.
Thank you very much.
And the same has to be decided by being alive to the entire facts and circumstances of the case before allowing a person full stop. I think that should be sufficient.
Deeply grateful, yes.
Because I am of that belief. You see, I cannot say 2 years.
Yes, your lordship order is very
Clear.
forceful and powerful,
Yes,
so
yes.
I don't want people to take
It will depend on facts of each case.
Oblige your lord.
Item 10.
There is one, I was just giving that just now, one, I think that. Just see, there's one judgment of mine. Yes, Miss Fanai, are you well?
My lord, I'm not well, but then I can proceed with the hearing.
Yes.
My lord, as we have discussed in the last court date, this is also about the long incarceration. And this is the second time that we have moved this bail application before your lordship.
2 years, 3 months?
Yes. It's not 3 months yet. It's a little more than 2 years, 2 months.
Okay. Yes.
That, my lord, we had made an application.
And PW 2 and
3.
3.
Yes,
Yes,
ma'am.
I think Miss Mary, who's appearing? Miss Vani? Yes, I remember some report was asked.
Yes, my lord, the LCR.
Yes, has it come? Updated status of the ongoing trial. Has it come?
Yes, it arrived.
It has
I
come?
believe It has arrived.
So what is the status? Why these 2 and 3, have they come or they have still not come? 16 to 15 times.
The court date is tomorrow. So by tomorrow we will
My lord,
be
they'll
able to
still
know
not
that
turn
whether
up.
they will appear before
Alright,
the court
then
or not.
we'll take it up tomorrow.
My lord, we have. I think this is the third time that we've had this.
No, you see, I shall not accommodate them more, because since we have already by a judicial order, we wanted to know the up-to-date status. Now the fact that these 2 and 3 are coming, because total how many witnesses were there?
Altogether
witnesses.
6.
Yes, out of 6, 2
Out of
witnesses
6,
were examined.
2 were examined, and these 2, the remaining 2 witnesses were not coming, despite
coming.
15 to 16 times each
13,
of them
13 times.
has been called.
Till date. It's
Now the fact, Ms. Fanai, that tomorrow is fixed, I think with all fairness, we will like to wait and watch what happens tomorrow.
My lord, the learned special judge is on leave till 27th.
All right, then till
27th. This
so
week.
The trial, the records have come, and you have seen the record, Ms. Bani?
Yes, Your Lordship, I have seen it.
So they have how many times they have been called?
13.
13 times. They have not come.
Yes,
Both of them.
both of them.
Heard MS Fanai, L. Fanai, Learned Counsel appearing for the petitioner. Stop. Also heard MS Vani, Learned APP for the state respondent. By way of this petition, under section 483 BNSS, read with section 37 of NDPS Act, comma, the petitioner, accused petitioner I. Shri Thang Songa is seeking release on bail, who was arrested on 18/5/2023 in connection with SR number 334/2023 arising out of special narcotic PS case number N-33/23 registered under section 21C/29 of the NDPS Act so and so.
Your Lordship, the accused is also booked under 14 Foreigners Act.
However, my lord, in the charge consideration, trial is against only as per section 21C and 29. It is on record.
Okay. Where is the brief facts? Where do I get it?
My lord, page, the FIR.
This is the second time you have come?
Yes, my
if
lord.
I recollect. Correct.
FIR is at page
1
59.
second. Then it's all right. it would be pertinent to mention that the accused petitioner has earlier approached before this court by way of bail application stroke 4 of 2025 for release of the accused petitioner on bail. However, this court by order dated 14/2/2025 rejected the bail petition. Stop. You take paragraph 3 of page 71. MS Fanai, Learned Counsel for the petitioner, submits that earlier this court, while rejecting what weighed in the mind of the court while rejecting the bail petition, was that out of the 6 witnesses, 2 witnesses have already been examined, and therefore the trial was likely to be concluded soon. However, she submits that since 14/2/2025, out of the 6 witnesses, except the aforesaid 2 witnesses, none has been examined till date. She further submits that PW2 and PW3,
Yes, my lord.
correct,
Yes, my lord.
who has been summoned repeatedly almost 15 to 16 times, have not appeared before the trial court to give their respective depositions. She further submits that since the accused petitioner has been languishing in jail since more than 2 years, 3 months.
2 years, 2 months, and 3 days. Today is
2 years, 2 months,
3 days.
3 days, comma, in view of such procreated incarceration, the accused petitioner is liable to be released on bail forthwith. Per contra, MS so-and-so, don't say per contra. In order to ascertain as whether the change of circumstances as projected by MS Fanai, Learned Counsel appearing for the petitioner, in support of her second bail application, comma, this court by order dated 18/7/2025 requested MS Vani, Learned APP, not requested. This is the registry, no?
The registry.
Call for the up-to-date scan copy of the trial court records. MS Vani, Learned APP, upon examining the aforesaid scanned copy of the trial court records, submits that it is correct that a part of the 2 witnesses out of the 6 witnesses who was already examined at the time of the first bail application, comma, none of the remaining witnesses, despite 2 of the witnesses having been called more than 13 times, have turned up before the trial court to give their deposition. heard, perused. Apt at the outset to refer to the relevant paragraphs of the order dated 14/2/2025 passed by this court, whereby this court was pleased to reject the prayer of bail made on behalf of made by the petitioner, accused petitioner, which reads as under, quote unquote, page 72A to A. It appears that this court, upon considering that the trial it appears that this court, upon being satisfied that there are reasonable grounds for believing that the petitioner is guilty of the offense charged, rejected the bail prayer. It further appears that the argument it further appears that though at the time of hearing of the first bail application, the learned counsel appearing for the petitioner, accused petitioner, submitted that out of the 6 prosecution witnesses, only 2 has been examined by the trial court, and the matter has been lingering for several days before the trial court. This court, upon noticing that out of the 6 witnesses, 2 witnesses have already been examined, was of the view that the trial is likely to be concluded soon. It appears that the accused petitioner has been in jail since 2 years, 3 months. 2 years, 2 months, 2 days till date, and full stop. It further appears from the scanned copy of the trial court up-to-date records that after 14/2/2025, though almost 13 times, more than 13 times, the 2 witnesses out of the 4 remaining witnesses, 4 prosecution remaining witnesses, having been summoned, has not appeared before the trial court till date. And for this reason, the trial is being delayed. Taking this aspect in mind, it appears that the trial is unlikely to conclude soon and is, that apart, MS Fanai, learned so and so, informs that presently though, don't say that. It further appears that the next date fixed before the trial court is tomorrow, so and so date. However, MS Fanai, learned counsel appearing for the petitioner, accused petitioner, informs the court that the trial judge is presently on leave. Considering that the accused petitioner has been languishing in the jail for more than 2 years and the trial is moving at a snail's pace, proceeding at a snail's pace, and that there is no criminal antecedent against the accused petitioner, the fundamental right of the accused petitioner under Article OP, this part, snail pace, you just full stop, and then that last I have already given you, no? Can you put this together? Just copy that last part from there. Okay, and show me once. I think just the earlier one which I gave, no? What, or you say it like this. Before you say that, you say, it is thus evident that the petitioner is behind the bar for more than, accused petitioner is behind the bar for more than 2 years from the date of his arrest, and till now the prosecution has been able to examine only 2 witnesses, and despite 2 witnesses out of the remaining 4 witnesses having been summoned for more than 13 times, have not appeared till date before the trial court to give their deposition. Thus, it cannot be denied that the prosecution needs a considerable period of time for completion of the trial. That apart, there is no adverse criminal antecedent against the accused petitioner. Then you put that paragraph where I referred Ravi Prakash and quote that same paragraph. Okay? After that you say, in the facts of the instant case, the accused petitioner has already spent more than 2 years in custody and the trial is proceeding at a snail's pace, and hence the fundamental right of the accused petitioner under Article 21 of the Constitution of India is clearly violated. In view of the aforesaid foregoing discussion, violation of the rigors of section 37 of the NDPS Act so and so shall not affect the power of this court to grant bail to the accused petitioner. Hence, I shall be failing in my duties if the accused petitioner is not released forthwith. Stop. Therefore, further detention of the accused petitioner in the custody is totally unjustified. Accordingly, the accused petitioner, namely so and so, shall be released on bail in connection with so and so on furnishing bail bond of rupees 50,000 with 2 local sureties of like amount, provided that one surety has to be a government servant. To the satisfaction of the learned
Special judge.
Special judge.
Indian PSI.
Learned special judge, special judge, No, it will be Learned Special Judge, Special Court. Or Judge Special
Judge
Court.
Special Court of
Judge
India NPS
Special
Act.
Court, NPS Act, Aizawl, Mizoram, subject to the following conditions, 1, 2, 3, 4. Accordingly, the bail application stands disposed of.
Obliged.
And that last paragraph which I gave earlier, you repeat this here. It is needless to be clarified, that paragraph. This is scan copy, not to return. Huh? Give this to return, and give that order. Have a look at this. Okay. Yes, principal bench. We are. The part 1 is over, right? Yes, principal bench.
I have retired from contesting here in this bench, Your Lordship. So a number of times they have been absenting. So if in the next court date, the matter,
Who appears for the?
if none appears for the CADC, let the matter be proceeded ex parte against him.
Who appears for the? Is there a standing council? Anybody has?
They don't seem to have a standing council.
No, but in this RFA, has anybody entered appearance?
Not in this proceeding, Your Lordship.
So then I'm sure now this matter is fixed for hearing.
Yes.
So nobody has appeared till date.
Nobody has appeared.
There must be orders.
There's an order, yes.
The orders must be already there. This court will not wait for them.
In fact, the order of the Apex Court.
No, before Apex Court, please find who first of all, which is the respondent, Chakma Autonomous Council.
Your Lordship, the respondents are CADC and then the Chief Executive Secretary.
You are Lalnun
Lalnun, Your Lordship.
Sorry?
Lalnun, Your Lordship.
Lalnun Rui.
So, Your Lordship, Chakma Autonomous District Counter represented
respondent
by the
number?
That is respondent number 3, Your Lordship.
3.
3 is Chakma Autonomous District
Now,
Council.
let me see if there is any order. What
3,
happened?
4 and 5 are the CADCs, Your Lordship. CADC are respondent number 3, 4 and 5.
The office note of 2625 says the postal receipt for R3 is not tracked. And how does this matter got fixed for hearing? Huh?
Earlier, Your Lordship, Mr. A.K. Rokum, he was holding the post of
No, that's okay.
Additional
but,
Advocate General appearing for the state, as well as
Mr.
Chakma
Lalram
Autonomous
Baba, are you following what this court is asking you? Art 3, there has to be a judicial note, isn't it? Either accepting or something, deeming acceptance, because the office note of 28th June indicates the postal receipt is not received by the registry from the postal department till date. Despite all efforts to recover the postal receipt from the post office, it was verbally reported that the same could not be reprinted or relocated. Under such circumstances, the tracking of the said consignment could not be done. This is for R3, Chief Executive Member, CADC. R3, right?
Yes, Your Lordship.
So then, is there a standing council? No.
No, Your Lordship.
What is to be done? A fresh step. Fresh step. How can we proceed? And why the matter is fixed for hearing?
R3, Your Lordship, R4, 4 and 5.
3, 4 and 5.
If there is any receipt of notice.
Nothing is there. But why is this matter posted for hearing, Michael? Just check, because this should have come for orders. Why is this matter in the hearing
It's
list?
because of the direction of the Apex Court, Your Lordship.
Correct, but then how notice has to be completed, no? We can this court hear without the completion of the notice? Who? I think you look into it. I can have this matter called tomorrow. It's in the hearing list. Mr. Ramjoma, because you check, because I'm trying to help you here. You see, if you want, we can do fresh steps, and then, or if you want to do dusty surveys, you can do it, file an affidavit, and thereafter the matter can be placed for hearing. But unless and until the notices are complete, can this court take it up for hearing only because the matter has come back from the apex court? The formalities has to be done. Tomorrow, if we go ahead with the hearing without any judicial order complete as regards the completion of the notice, the order of this court would be a nullity, natural justice. Yes or no?
Yes, yes, that is one thing.
So, you understand the position. So, some clarity has to be there. After giving opportunity to all the parties, we therefore allow this appeal and set aside the judgment and the order passed by the High Court dated 19/6/18 in RFA 33 of 2013 and remand the matter back to the High Court for hearing the appeal afresh after giving an opportunity to all the parties. Yes. I think after this an order has been passed. Yes, show me that order. I just saw one order, a notice. I think this is after this. Which this order came on 28/2/24, and then yes, notice was issued. All right, take down. Heard Mr. C. Lalram Zwava, learned senior counsel, assisted by Mr. So-and-so, learned counsel appearing for the appellant. Stop. Also heard M.S. Lalnun Rui, learned government counsel for the state respondent. It appears that upon receipt of the apex court's order dated 28/2/2024, passed in Civil Appeal number 6398/2023, whereby the matter was remanded back to this court for fresh consideration after giving an opportunity to all the parties, this court on 28/2/2025 on 26/3/2024. On 26/3/2024, issued notice to the appellant as well as the respondents through their counsels stop. Michael, this order 26/3 is also here. Where is 26/3? Can you just take out 26.3? This is important, huh? 26.324. Before this, it will be just the one order before. In the meantime, just find out who was earlier appearing for the Chakma.
Mr. Ekeroku.
Mr.
Ekeroku.
Is he still practicing here?
He's still practicing. He was at that point of time government advocate, additional AG
At that time.
at that time.
Now he is not.
He's not.
This is not a judicial order. Not there. So I think the registry has that. Where was the earlier order? Yes. What did you write? What did you write? Not this court, the registry of this court had issued notice to the appellant as well as the respondents through their counsels okay? Full stop. Perusal of the order dated 28/2/2025 indicates that perusal of the order of this court, dated 28/2/2025, indicates that although the said notices appears to have been received by the learned counsels from a perusal of the AD cards received back, but the matter has not been listed until that date. Upon noticing that there was no representation on behalf of CADC, I responded number 3,
4 and 5.
3, 4, and 5.
3, 4, and 5. This court was pleased to issue notice to the said respondent, CADC, represented by its chief executive member, Kamala Nagar, Chongte with C, Mizoram, by registered post with AD. Stop. Thereafter, it appears that when this matter was last listed before this court on 24/3/2025, this court, upon perusal of the office note, observe that AD card as regards the respondent CADC has not been received back till date, and that the office and directed the office to track the postal consignment and put up a report by the next date. Today, inadvertently, the matter is posted under the, no, don't say the hearing column, I'm not saying anything. Today, when the matter is posted before this court, the office note dated 26/2025 indicates that the postal receipt is not received by the registry from the postal department till date, and despite all efforts to recover the postal receipt from the post office, it was verbally reported that the same could not be reprinted or relocated. And thus, the tracking of the said consignment as directed by this court earlier could not be done without the postal receipt at hand. Fresh steps?
I think that's the only way.
Huh?
That appears to be the only way.
Mr. Lalram Zaba, senior counsel, at this stage seeks issuance of fresh steps upon the respondent so and so. Accordingly, you will take it. Accordingly, his office is allowed to take fresh steps within a period of 3 days from today. List after 3 weeks.
Okay.
By registered post AD, as well as Dusty.
Dusty.
No. Okay.
That will be sufficient, Lordship.
Huh?
We'll make a, we'll track it.
So what? AD card?
AD card.
Only AD card.
Lordship.
Item 5.
Item 5.
Yes.
This has been pending for quite some time, but because of the absence of the respondents, counsel for the respondents, matter could not be taken up even on the last occasions.
When do you want it?
Lordship, there is one execution case. Inadvertently, while filing this, while moving this appeal, no stay order was obtained. Now that, because of that, the execution case is pending, and that execution case is in the process. I think if this matter cannot be taken up tomorrow, at least we'll have to seek for stay of the impugned judgment and order. Even
Who is appearing for the other side?
We have
Kianga? No.
Jonathan.
You inform them.
Tuanga.
Inform the other side. I cannot say anything about the stay, but it's in the hearing column.
Yes.
So it will be called out tomorrow. Please inform the other side counsels.
Right.
Yes. You don't have to write an order. It's a part to that. Anything else? All right.